A decision by Bankruptcy Judge Michelle Harner of Baltimore will be Exhibit A whenever Congress holds hearings regarding changes in our current law that very tightly restrict people's ability to discharge student loans in bankruptcy. And believe me, when you read this decision by Judge Harner, you will see just how cruel our current law can be with regard to people who, through no fault of their own, are simply unable to repay their student loans. In this case, that was in Judge Harner's court, the debtor was a 68-year-old single woman. To her credit, she went back to school and got her BA degree at age 51. She then went on and 4 years later got a master's degree. Trying for further education, she started an MBA program but was unable to finish. Sad to say for this woman, the education that she received was not good enough to qualify her for the type of job that she hoped to get as a result of her studies. As a result, her wages were $9 an hour, and by the time she filed a Chapter 7 petition, her wages had grown to $13 an hour. In the year before bankruptcy, the debtor earned a grand total of $43,000. And as Judge Harner explained, her gross income was that high only because the debtor had been able to work 60 or 80 hours a week. In other words, work enormous overtime because that overtime was available last year as a result of the pandemic. Judge Harner noted that, well, once the pandemic is over and this woman cannot take on so much overtime, her basic earnings at $13 an hour are not going to cover all of her basic living expenses. And believe me, as Judge Harner explained, they were not at all elaborate. It was really hand to mouth. Judge Harner looked at the law and decided that she was unable to discharge all of the hundreds of thousands of dollars of student loans that this unfortunate woman had incurred. However, Judge Harner read the law to mean that she was able to discharge some, but not all. And so what she did was to alleviate the woman's responsibility for repaying all but $12,000 of her student loans. But frankly, between you and me, the woman just doesn't have room in her budget to repay even $12,000 over the next 10 years, as Judge Harner would permit. And furthermore, the woman testified that when she retires, and she's eligible for retirement in another couple of years, her income is going to be limited to Social Security, and income's going to drop by half at least. Well, this all just goes to show that there is something fundamentally wrong with our bankruptcy laws when it comes to student loans. Let's hope one of these days Congress is going to change the law so that unfortunate people like this debtor in Judge Harner's court are able to alleviate their enormous debt burdens so they can return to society as wage earners, consumers who are able to spend and enjoy a decent life not encumbered by enormous student loans. I am Bill Rochelle, the editor-at-large for American Bankruptcy Institute. I will return same time next week with something interesting from the world of bankruptcy. Until then, be well.